Hello, I'm Jim Turk, the director of the Center for Free Expression at Toronto Metropolitan University, and I would like to welcome you to the Center's second panel for 2024-25. Before we begin, however, I'd like to acknowledge the land on which I am speaking to you tonight is the traditional territory of many nations, the Mississaugas of the Credit, the Anishinaabeg, the Chippewa, the Haudenosaunee, and the Wendat peoples, and is now home to many diverse First Nations, Inuit, and Métis. I'd also acknowledge that Toronto is covered by Treaty 13 with the Mississaugas of the Credit and the Williams Treaties signed by multiple Mississauga and Chippewa bands. I'd also like to thank our co-sponsors for tonight's panel, the Observatoire de la Liberté d'Expression at the Université de Quebec, Chicoutimi, and Penn Canada. This spring and summer, protests about the war in Gaza broke out on dozens of campuses across Canada and Quebec, from Newfoundland to British Columbia. University administrations responded in many ways, from almost immediately calling in often brutal police repression, to seeking injunctions, to negotiating creative resolutions with the protesting students, faculty, and staff. In tonight's panel discussion, we're going to address a number of questions, which generally revolve around where does this leave the rights to freedom of expression and of assembly in universities? Specifically, what are the rights students, faculty, and university staff have to protest on campus? Secondly, more broadly, what are the expressive freedom rights for all Canadians, and what are the legitimate limits to those rights? Thirdly, how should these matters be dealt with in future by universities, students, and faculty, the police, and the courts? And finally, to what extent must universities act in a manner consistent with the Canadian Charter of Rights and Freedoms and with the Quebec Charter of Human Rights and Freedom? So I'd like to introduce our impressive panel who are going to be discussing these questions. First is Jamie Cameron, Professor Emerita of Constitutional Law at Osgoode Hall Law School at York University, and widely recognized as one of the leading experts on free expression constitutional law in Canada. Welcome, Jamie.
Hi.
Our second panelist is Sarah Hamill. She's a Canadian, but she's an assistant professor of law at Trinity College, Dublin, and she's written extensively on freedom of expression, encampments, and property rights. Welcome, Sarah. And I should acknowledge for the audience, Sarah's making a significant sacrifice to be here because it's now just 4 minutes after midnight her time in Ireland. So we're grateful for your late night participation in our panel. Welcome, Sarah.
Thanks, Jim. I should also point out I'm not actually Canadian. I just sound Canadian.
Okay. Our third panelist is Louis-Philippe Lampron. Louis-Philippe is a professor of law at the Université Laval, and he's written about academic freedom, the Charter of Quebec values and the workplace, and freedom of expression, and about the 2012 student strike in Quebec, which in a lot of ways raises many of the same kinds of questions. It was a landmark, for those of you who don't remember that strike, a landmark in student protest in this country and in Quebec. Thank you for joining us, Louis-Philippe.
Thanks you. Good evening, everyone.
And finally, our fourth panelist is Finn Makela. Finn is a professor of law at the Universite Sherbrooke. He specializes in labor and employment law, higher education law, and has also written about the 2012 student strike in Quebec and its implications for freedom of assembly and expression. Welcome, Finn.
Hi, thanks so much for animating this debate. I'm just going to quickly turn off my camera because apparently I have a focus problem, but I'll be right back.
Okay. So the format for tonight's discussion is we're going to have a conversation amongst the panelists for 45, 50 minutes or so, and then we're going to turn to the audience for your questions. We're using a version of Zoom, a webinar version of Zoom, in which the chat doesn't function, but there's a Q&A button at the bottom of your screen. So if you look at the bottom of your screen, you'll see the Q&A button. I think it's a little box with a question mark in it. And we'd encourage those of you in the audience as questions come to your mind as you're listening to any of our panelists and you'd like to ask them or the whole panel a question, just write it down at the time you're thinking of it. You don't have to wait till we turn to the audience to do so. And then when we get to that point where we're turning to the audience, I'll ask Ange Holmes, who is the coordinator of the center, to read out the first question. She'll read it out and then the panelists will answer it. We'll go to the second question. So we really hope you'll be inquisitive and ask lots of questions. There's so many complicated and important issues to discuss, and we're really looking forward. I know the panel's looking forward to addressing the questions that you have. So why don't we start with actually a very general question that I'll pose to all of you, which is, what rights generally do Canadians have to protest, and what is the basis of those rights in Canada and in Quebec? Jamie, would you like to start?
Well, sure, and this is pretty basic. I mean, I think most of the people in the audience would know that rights of protest are protected under Section 2 of the Charter, specifically freedom of expression under Section 2B, and the much overlooked guarantee of freedom of peaceful assembly under Section 2C of the Charter. And so those are the core protections for rights of protest. And of course, as most of the audience would know, these rights can be asserted against the government and violations by the government of these rights. And as we'll be discussing tonight, the degree to which these same rights are protected or respected by universities, I think varies a great deal depending on local rules and regulations and policies. I'll just leave it at that for now, Jim.
Louis-Philippe, with regard to the Quebec Charter, how does that come into understandings of those in Quebec?
Yeah, that's an excellent question. We're talking about the application of the Quebec Charter. Contrary to other human rights acts in different provinces and territories, the Quebec Charter protects broadly human rights and fundamental freedoms. So when we're talking about the protection of freedom of speech, freedom of expression, and its corollaries, it's protected not only against the government, but against private entities as well. So all the questions that will be addressed tonight about is the Canadian Charter applicable to Canadian universities and to which extent, we don't have to ask this question in Quebec, because Quebec universities are submitted to the application of the Quebec Charter. So this particularity of the Quebec human rights law is really interesting and poses a lot of really interesting questions. And when we're talking about the implementation of the right to protest, context is everything. So the fact that, and we saw it during the 2012 student strike movement, the Charest government then tried to limit the scope of the movement to an individual boycott movement, and that was everything, because if it's a boycott movement, then you have less right to force someone else to respect your wish, your individual wish to boycott. But if it's a student strike, we're talking about a collective protest, and then it's asking other questions in the student movement. So we'll be able to talk about that tonight.
Ben, do you have anything you'd like to add with regard to Quebec?
Yeah, and I agree with, I mean, we're in basic principles here, so unsurprisingly, I agree wholeheartedly with everything that Jamie and Louis-Philippe said. But I think it's also important to underline for the audience that freedom of expression, freedom of assembly or peaceful assembly doesn't mean freedom to not bother. And in fact, in the kind of years following the Maple Spring, where there was an immense amount of action, including municipal bylaws to try and limit protest, there was a series of court decisions that said, well, protests are designed to be inconvenient. It's part of the nature of the expression that they're inconvenient, and that can include things like refusing to give police an itinerary prior to a march. That can include things like blocking traffic, because the Highway Traffic Act had been used to shut down protests, and that includes city bylaws, which can't unduly stop protests, including in one decision that state authorities can't require protesters to protest unmasked because of the possible chilling effect of reprisals. And I think that this whole notion of doxing has been important in the encampment issue too.
Could I just add one quick little thing?
Sure.
Which is to say that the point of an assembly or a gathering or a protest demonstration is to be disruptive. And so an assembly that is disruptive is not necessarily unpeaceful. And so there is a tendency to equate disruption with not being peaceful, and that's just not correct in principle, but we'll deal with that later, I think, as we go along.
And Sarah, I mean, you've been studying Canada and writing about Canada from an international perspective. Do you have anything you wanted to add in terms of general rights that Canadians have to protest and what you've heard from your colleagues on the panel?
I mean, I agree with what they say, but I am the sort of the rogue property lawyer or popular law scholar on the panel. And so I would point out that very often when people are exercising their rights under Section 2C, they do need to access property that they themselves don't own. And this gets into a different series of questions. And sometimes when you read the case law from Canada, even though we know that protests are supposed to be disruptive, or not supposed to be, but part of their way of being is they are slightly disruptive, sometimes Canadian courts can be a little bit reluctant if they're too noisy or they're too disruptive. And, you know, if they would come in what private law is known as a nuisance, Canadian courts can be a little bit concerned that there may be too much of a nuisance. And so we've seen that in some of the case law as well.
Have we seen any difference in the case law in Quebec as opposed to outside of Quebec? That is, when you were talking about some of the cases following the Maple Spring in 2012, were those based on the Quebec Charter in Quebec, or were they more general?
There was not a lot of, as is often the case when the litigation is against the state, there's very little discussion in Quebec as to whether they're talking about the Quebec Charter or the Canadian Charter, because they've been held by the courts to essentially be coextensive in the rights that they grant. One thing that in other areas of protest that I see regularly in my work as a labor and employment lawyer is that the picketing jurisprudence in Quebec is particularly stringent when compared to political protest and compared to other provinces. So the regulation by picketing by injunction is still very much alive in Quebec, and labor picketing is variable in Quebec in comparison to other provinces.
So let's turn more particularly to the encampments. As I mentioned, there were more than 24 of them right across the country. Could each of you give us a brief overview of the encampment on your own campus or another with which you had contact, and how the university's administration dealt with it? Jamie, do you want to start?
Sure. I'm a retired law professor from Osgoode Hall at York University, so I wasn't there, but I can let members of the audience know that York University did have an encampment. It was one of the later ones to get going. I believe it was not established until June 5th, which would be quite a while after other encampments have been set up at various other universities across Canada. But what's interesting about the York encampment is that by June 6th, it was gone. And so the university issued a trespass notice almost immediately and notified police. And within 24 hours, the encampment was dismantled with the assistance of law enforcement officials. So it's interesting, just very briefly, to compare the situation down the road at the University of Toronto, where the encampment was in place for more than 50 days until the university was able to go to court and get an order compelling it to disperse. So one of the things that I think we see in comparing encampments across Canada is one of the dynamics is high degree of variability in police responses. The police didn't have any hesitation, apparently, to go to York University at the university's request And meanwhile, down at the University of Toronto, I believe I'm correct in saying that the police refused to come and assist with a mandatory dispersal in the absence of a court order. So while the York University encampment had little or no opportunity to get its protest going, the University of Toronto encampment was able to conduct its demonstration for a substantial period of time. That divergence is quite interesting to me.
Finn, could you tell us about your experience of the encampment?
Sure. So I teach at the University of Sherbrooke, but I live in Montreal, and I have also similar to Jamie, a kind of a tale of two campuses, McGill University and Université du Québec à Montréal, UQAM, which is just maybe 10 blocks away. So McGill's was one of the largest and longest of the encampments. It started on April 27th. 2 days later already, McGill had denounced some of the signs as being anti-Semitic and called the police. And what was really interesting throughout both the McGill encampment and the UQAM encampment is the police systematically, from the very beginning until the very end, refused to intervene at the behest of universities. I suspect, and Louis-Philippe could maybe talk about this eventually, but this is the result of kind of a shakeup in policing in Quebec of protests in following the Maple String in 2012. So there was a lot of litigation. McGill at the McGill encampment. First, there was an injunction filed by third parties, so not by the university, but by students who said that they felt unsafe. That was rejected by the Superior Court on the basis of the pleadings of the evidence that was pled, who said, "Well, look, you're not actually alleging anything illegal, and you're not the owner of the property." And the fact that some of the slogans make you uncomfortable or make you feel psychologically unsafe doesn't actually count as a genuine threat to your safety or well-being that would justify the court intervening. So then, so that was on April 30th. In the meantime, the premier was starting to try and order police in through press conferences, which was surprising. And then finally, McGill filed an injunction. And then again, the judge, hearing the initial safeguard order, said, well, there's complex issues of freedom of expression in the context of a university campus. And I don't think that we should do this on the basis of an expedited hearing. So I invite McGill to refile with clearer pleadings, and we can hear this at a later date. And so eventually what happened after talks broke down was that McGill signaled to the police that they were going in with private security and bulldozers. And so the police showed up and essentially escorted the harassed campers off of and in some sense, you could even be said protected them from McGill's private security. Down the street at UQAM, it was a whole different story. It started on May 12th. On May 27th, the university filed an injunction, and they said, we don't want them to stop the encampment. Like that, they're welcome to do that. That's protest is a normal part of the university campus. But we'd like 3 meters from the building. We want to make sure that no fire exits are obstructed, that they're not blocking entrance to buildings and so forth. And so that was that injunction was granted, but it was very limited in its scope. And then 2 days later, the UQAM Board of Directors adopted a resolution divesting of all shares in arms company, calling for a ceasefire, setting up a program to bring Palestinian academics and students from Gaza to UQAM, and with a budget set aside for that, and a promise to communicate all those decisions to all of the principals and rectors of universities across Israel and Gaza. And then on May 6th, the campers said thanks, and they broke camp and peacefully went about their business.
Louis-Philippe, did you have anything you wanted to add, either based on what you experienced in Laval or what you saw elsewhere in Quebec?
Yes, maybe just a little add on to what Finn just summarized about the essential distinctions between the UQAM way of handling the encampments and the McGill one about fire hazards. It was one of the main reasons that were put forward by university direction to dismantle the encampments. And again, the approach was totally different between UQAM and McGill, because McGill, they alleged the fact that there were fire hazards, but they weren't able to prove that they were fire hazards, so they lost. They weren't able to prove that. But at UQAM, they asked for the right to, I think, firefighter to access the encampment to check if there were fire hazard, and they were allowed to do that. They were granted this part of the injunction as well. So it was really, I would say, playbook way of the handling an injunction for UQAM, and it was the contrary. It was a Harvard case study of a fail for McGill. When we're talking about Laval down the St. Lawrence River, it's a really weird situation, because when we're talking about, and maybe we will, in fact, I know that we will talk about academic freedom issues with student encampments on campus. But the fact is that the way that Laval University handled the beginning of an encampment on its campus, there's a lot of blur around the situation, because police intervened from the moment that they heard that there was going to be an encampment on Université Laval campus. So it was on June 2nd, and they refused the encampers, the protesters, the right to place leur tente, en fait, de placer leur tente, put their tent on campus. And afterwards, there was kind of this, and it's still going on, this fight between Quebec police forces and Université Laval direction to who is responsible for this decision, because our direction is pretending the fact that they didn't have the choice, and they were informed by the police forces that they had to stop the encampment from happening. And for the police forces and the Quebec City authorities, they are referring to an agreement between Laval University that was put forward a month prior to the encampment situation, and this was this agreement that would force the police forces to intervene. So there's kind of a blur, and this problematic one, because we're talking about, when you're talking about academic freedom, you're talking about institutional autonomy. And the fact to think that authorities of the Université Laval just gave the keys of the university to police forces and say, okay, so now you will decide what type of collective activities that may happen on our campus, and what are the collective activities that may not. And I'll finish on that. The property right arguments are really important in the matter, but it was taken the other way around by our university direction, and we still haven't found the answer to who is responsible for this decision of June 2nd.
So Sarah, could you give us a little bit of an international perspective? I think you had an encampment at Trinity College, Dublin. I don't know if there's anything from that you'd like to share, and then any more general comments on some of the variability you saw in Canada.
Yeah, so the backdrop behind me is a picture of Trinity campus. It doesn't actually show where the encampment was. And I think it's probably helpful if I just describe campus a little bit so you get a sense of how it operates. Because Trinity was founded in the 1500s, the campus is quite old, and you can actually close campus off entirely. It's surrounded by, walls and buildings, and so campus can actually be locked down, and historically it would have been closed to anybody who didn't have reason to be there. So we had an encampment as well, and this was, the students had been protesting prior to the encampment, which was happening around the same time as all of the other encampments. I don't remember the exact dates. And in response to that, campus was somewhat closed off to those who weren't staff, students, or invited guests, as I recall. But the university administration did negotiate with the students. Now, anecdotally, there were some reports that some university buildings may have, as the protests continued over a number of days, some university buildings may have become closed to the students, and that they found their student cards wouldn't let them in, or that the buildings that were normally open were locked. But fundamentally, this was a negotiated process, and the encampment did come to an end as a result of that. There was, as far as I'm aware, no litigation, and that pattern was seen at other universities in Ireland and in the UK. Not all, it wasn't a universal pattern, but I was at a conference in Reading in England last week, and they also mentioned that there was an encampment on their university campus, and there was also a negotiation there. So there hasn't been quite the same level from what I've seen, particularly in Dublin, of the heavy-handed responses that we've seen in some of the university campuses in Canada.
Well, one of the things that stands out from your descriptions is the enormous variability in how university administrations responded, how the police responded. In the case, in Canada, as you've described some specific cases, we had those universities like York or the University of Alberta or the University of Calgary, where the police were called in very soon after the encampment was set up. And certainly in the case of Calgary and Alberta, those universities, the police behaved in what's reported as a very brutal fashion in shutting it down before much protest could even take place. And then you had others who, in trying to shut it down, didn't rely on calling in the police, but seeking an injunction to let the court decide whether it was appropriate to invoke the police. And then you had others like UQAM or the University of Windsor and a number of others that entered into serious negotiations with the protesters and reached an accommodation that led to a voluntary closure of it. But I'm just struck about the variability of how that, and then the reactions of the police, the contradiction that Jamie discussed. The Toronto police went in immediately when York asked, refused to go in when Toronto asked. As I understand, their position was, well, this is your property. If there's a problem, we only go in if there's a violation of the law, and we don't see any indication of a violation of the law. So we're not going in just because you ask us to police your property. And then the responses of universities too was in part not wanting to alienate donors, not wanting to alienate people in the community. So this real melange of responses indicates sort of no consistent theory or understanding of free expression rights or obligations of universities. I don't know if any of you have any other things you want to comment on this variability before we go on to the next part, but if you do, please.
Well, I would just say that the variability, to my mind, is a function of the lack of standards for rights in this university setting and this ongoing outside of Quebec ambiguity about whether the charter does apply or doesn't apply, or whether we have charter values but not the charter. And short of some sort of framework of constitutional legality or legality to deal with these issues, what we saw happening in the court cases, at least in outside of Quebec, was that property rights trumped the right to protest. And even in cases where there were findings of fact that there were no transgressive expressive activities and the encampments were peaceful in nature. So under the charter, those elements would be protective of rights, but once property rights were invoked and trespass law came into the equation, there was no space in the adjudication for rights of free expression and peaceful assembly. And so you sort of, I'm left thinking that rights of protest are essentially at the unreviewable discretion of the university. They have policies that are, according to the judge in the Toronto encampment case, directionally similar to the charter, but that didn't really mean anything, particularly in the context of findings of fact that there were no transgressive activities and that the encampment was peaceful. So, I think I find that problematic and actually kind of unthinkable that the degree to which students might have rights to protest on university property is at the complete discretion of the university. And they all have free speech policies. They all have policies and protocols, but they weren't designed to deal with this kind of situation. And so there was a gap in legality there that allowed the law of trespass and property rights to trump everything else.
Go ahead, Louis.
And I would add, if I may, the fact that even in a jurisdiction as Quebec, when we have a charter applicable to the university campus, the question of property right was central to the controversy, and it was central to the anger of our prime minister, saying it's not common sense. Huh? He was using this line in French. The fact that McGill University is not able to force the dismantlement of the encampment because it's their campus, it's their property. And so we were completely forgetting about the fact that the places on which those encampments were situated were not like the office of the rector or a classroom. They were public places accessible to the public. So there's private property, and we were not talking about it, even in Quebec, and even in a situation when private institutions like University have to respect the freedom of speech and the right to protest. And we were not even talking about the fact that those were student protests. So I totally agree with the fact that those university policies about freedom of expression, they are all built the same, and they are all built around the discretion of the administration to authorize some and refuse some others. And when you're talking about disruptive protest, it's always refused at first, because university administrations don't want to be disruptive. So,
well, could we drill down on this for a minute? Because in fact, there were some places where they didn't invoke property rights, where they actually engaged in serious discussions and ultimately a resolution with the protesters. And then there were, I mean, to just elaborate on Jamie's point, when we look at the two injunction cases in English Canada that went to court, that was at the University of Toronto and at Vancouver Island University, Judge Conan in the Toronto case was very clear about the things you're talking about. I'll just quote from paragraph 212 of his decision. There is no evidence to suggest that the named respondents, that means the protesters, have engaged in any acts of anti-Semitism, racism, violence, hate speech, or vandalism. The record before me suggests that the named respondents are young idealists who are motivated by immense human suffering, sometimes that of family and friends. To this point, the police have not been prepared to intervene in the absence of a court order. And then he goes on to say, but I'm granting the injunction because of the university's property rights. And in the Vancouver Island University case before the BC Supreme Court, Justice Stevens wrote, in my view, the university has not demonstrated a strong prima facie case in relation to violence or the anti-Semitic nature of the expressions used in the encampment itself. As set out earlier in these reasons, the evidence of violence is largely hearsay, has not involved either the named respondents or occupants of the encampment, and is relatively isolated in nature. The expressions used within the encampment, such as from the river to the sea, have multiple meanings. There is no evidence to suggest that the named respondents or the occupants of the encampment use them in any way that is anti-Semitic or that is intended to incite violence. But then he went on to say, nevertheless, property rights trump, and therefore I'm granting the injunction. So it really clearly brings the need to address the university's, on one hand, strong stated commitment to free expression, to academic freedom, to engagement with difficult issues, with their willingness to suppress it entirely in the name of property rights.
Well,
If I could,
yes,
go
Joan.
ahead, Sarah, the property lawyer.
well, if I could sort of jump in there, the decisions are saying that there's no violence, but at the same time, what they're sort of implicitly saying is there's violence done to property rights. And that's an interesting, and that's, I guess, technically correct. And we need to sort of unpack whether we're okay with that. And I think there's scope to argue that sometimes we do have to do, be a little bit more flexible with property rights. But that is where the violence is, and it's implicit and it's not explicitly named. But as a property lawyer, that's what's coming through these decisions to my mind. So I'll let Finn chime in here.
Oh, well, this fits perfectly. Maybe you can enlighten us on ways forward or out of this kind of cul-de-sac. So I was going to mention that during the Maple Spring, one of the first decisions, quite literally, like, said the university, in terms of property rights, the university is no different than a shopping mall. With an implicit reference to a Canadian case, Harrison versus Carswell. That was a case of picketing in a shopping mall. There's been other cases in the jurisprudence handing out leaflets in an airport. And so there's this, we could look at this narrowly in terms of, well, is the university campus a special place, either because of the nature of the activities that take place there, or because of its general availability to the public and so forth? Or do we need to have a larger discussion about protest rights and property rights more generally, where it's clear to me that it's very different if somebody were to hold a protest in my backyard while I'm having a barbecue? Like, that's the kind of implicit background assumption of property rights that people have in their heads. But when you take things like semi-private parks, campuses, shopping malls, airports, these are all spaces that under different legal regimes would not be considered private property in the same way as my backyard is. And maybe we need to think of exploding that category in order to accommodate protest.
One of the points you're
If I
raising.
could just add very
I just wanted to ask a question to you, Jamie, and others related to this. I mean, we keep talking about university property rights, but actually the university property has properties of very different characters. The residents are like Finn's backyard. That is, those are the students' homes, and the right to protest and do things there are different, presumably. And if you
actually, Jim, there's a case from the 1990s. I think it's from the 1990s, from Queens, about labor picketing, where they weren't allowed to picket in a residence, but they were allowed to picket outside.
Right, and similarly, police have been willing to come in when there are occupations of the president's office or of internal buildings. So I think it's useful in this discussion of saying, what we're really talking about are protests that are occurring in the quasi-public space, what's often called the quad. We're not talking about the right to go anywhere in the campus. And I think it's useful to make those distinctions, because there it gets to be, I think, a more salient question to say, well, to what extent are those quasi-public areas of the campus, should they be governed by more public notions of protest rights than they are? I'm sorry, Jamie, I interrupted you. Started to respond to this.
Okay, well, I'll just say quickly that, I mean, I think the property rights argument had a huge amount of traction for a lot of people, including many of the people I talk to on a regular basis socially. There wasn't a lot of sympathy for the longstanding encampments. But I guess and I would not take any position that limits are not permissible in the context of the use of university property for expressive and other kinds of protest rights. Certainly limits are permissible, especially on duration. I mean, I think duration was really what was egregious from the point of view of property rights here. But what troubled me was that once property rights came into the legal analysis, and the law of trespass was invoked, it's as though there were never any rights of expressive freedom or the right to protest. But anyway, just turning to what you raised, and I'll just say very quickly so others can speak. I think that that whole issue needs to be dealt with prescriptively, so that there is clarity and transparency about the access to different kinds of university property for different purposes. And so that might be a tricky thing to do, but that's what the universities need to do. They need to think about and grant access to the places that are open to students and the public, and treat those as permissible spaces for purposes of expressive and even assembly rights. But then it's permissible at the same time to not to allow or not to grant access to other kinds of university property for those kinds of purposes. But it needs to be it needs to be transparent. It needs to be designated, prescriptive, so that there is some clarity that the rights do exist and that they can be exercised in certain spaces.
Louis-Philippe?
Yeah, I would say that when you're talking about the right to protest on campus and the fact that in Quebec, it's for sure that the university administration have to respect the Quebec Charter and the freedom of speech. But when you are opposing the property right of the university and the freedom of speech of its students, the question, and context is everything when we are in litigation involving the Canadian Charter or the Quebec Charter. If it is a student protest, the question that have to be asked is who is owning the university? Is it, if it's its administration, then okay, we can just cut to the chase and say, my house, my rules. And though the administration is deciding, and it's a validation of the pure discretion of the administration to determine which kind of protest is allowed on campus and which kind of protest isn't allowed. But historically, and I'm referring to one of the intrinsic limits to freedom of speech in the Canadian Charter, when you have to, because you cannot protest. If I want to make right now, I'm sorry, Jim, I know that it's supposed to be for later, but if we do a comparison to what happened on Parliament Hill, with
that's my next question about
with the Freedom Convoy,
right.
We were confronted to an intrinsic limit to freedom of speech. You cannot use a public space in a way that is blocking the access to others to this public space. I'm a French-speaking professor, so I'm not, summarizing it correctly. So correct me for my summary, but it's the essence of the intrinsic limit. And when you're talking about student protest on campus, and those encampments were those kind of protests, you have to ask the question, historically, campuses are places where students have the right to protest because they are at home. They are owning the place. This is the principle of academic freedom and collegiality. In principle, institutions, universities are not public institutions like any others because of the collegiality argument, and it has to be taken into context when you are arbitrating a conflict, an apparent conflict between freedom of speech of student and the property right.
I think I disagree with you. The beginning, you said that the occupying a space and excluding others is the intrinsic limit. I think it's the very nature of the encampments, as it was, for instance, with Occupy Wall Street and the Freedom Convoy, that they were arrogating for themselves exclusive use of the space. And I think Jamie's gesturing towards duration as being, well, and I think the other thing with the Freedom Convoys is that they weren't just blocking the space,
the road,
but they were also having effects larger outside of the space, right? Like people who couldn't sleep because of the constant honking and so forth. And that was brought up with some of the discussions around encampments, was that they're not bothering anybody.
But in French, we are totally agreeing. Those were the limits of my English capabilities. So thank you for summarizing it better than I could.
But I think Louis-Philippe made a very interesting point about universities being a community, because historically they would have been a residential community. And in fact, many of the buildings that you see behind me are actually in part residences for students. So, I would say that when if it has to come to being very prescriptive, obviously university affiliated individuals would have maybe a certain priority over accessing the spaces that are available on campus. They already have that in terms of like room bookings, but in terms of, having a protest on the quad, or things like that. But obviously unaffiliated individuals do come onto university campuses. They are sometimes invited on, and both for, commercial and non-commercial purposes. For example, they can be members of a university gym, or they can be accessing public transport, because many universities have public transit centers, but they can also be coming to attend talks that are being given in the university, because obviously universities are about public education. as well as educating, students. And so there isn't this sort of strict barrier. There are invitations to come on campus. And generally speaking, even though universities may say they would remove unaffiliated individuals at any point in time, realistically, if you go onto a university quad and you sit on a bench and you eat your lunchtime sandwich, nobody's going to bother you. And so it is basically a de facto public park. And I would be hopeful that universities would be more open to opening their property and recognizing that they've kind of already done that, and that it's actually a good sign that members of the public think that they should come to university to raise these issues.
Louis-Philippe raised, he was talking about collegiality being a factor. If I could just ask a question related to that. I mean, just to clarify, I think Louis-Philippe was absolutely right that universities are a different kind of institution than virtually any other in our society. And certainly the tradition has been one of collegial governance, going back to the first universities, the University of Paris, the University of Bologna, where in fact the university was the academic staff, and it was run more like a guild. And that has transitioned down to what we have in Canada now, which is a notion of collegial governance, where there's a senior academic body that is responsible for academic matters. There's a board of governors for administrative matters, but a lot of matters are a combination of the two. So the notion that these decisions just automatically belong to the university administration are not so clear-cut in Canada. And I think a better understanding and engagement with what does collegial governance actually mean, and what rights do the faculty and students who make up the university have in making those decisions, is a really important element that we have to work through in dealing with the issue before us right now. I don't know if any of you have comments on that.
Well,
I totally agree.
I agree, but I think I have maybe a little bit more a more radical view of lawmaking than maybe Jamie has when she says that that we need to be prescriptive, and maybe even that you're gesturing towards that faculty and staff and students ought to have a say through formal mechanisms of explicit rulemaking. So much of law, the legal theory nerds will make the distinction between law on the books and law in action. And so much of law is created by citizens, by individuals who are taking up space, resisting the police, deciding to do something, and eventually that's the continual interaction of human conduct is what gives shape to the law. And eventually that might be ratified by some sort of rulemaking body as kind of the common sense of the rule that we ought to adopt. But I think setting out in advance that explicit rulemaking bodies are the end all and be all of deciding legality is not only probably sociologically wrong, but can be somewhat dangerous, because you get these, if we say, well, it should be more prescriptive, it might be, well, yes, you may absolutely have an encampment and you may disturb between 7 and 12 on Mondays, alternating, provided that you have a permit. And so we've been prescriptive about it.
Well, can I
would put my money on bright line rules protecting rights of protest long before I would put it on just letting things happen and hoping that it will catch.
It did in Quebec. Well, everything everybody did in 2012 was illegal, and it is now the state of the law.
Well, with regard to being prescriptive, we did have some experience in the aftermath of the encampments in Ontario, where the University of Western Ontario, now called Western University, which has, by the way, one of the very best statements on freedom of expression in the country, brought forward after the encampment procedures for demonstrations on campus, a policy on procedures for whereby anyone who wanted to participate or have a demonstration, which consisted of one or more persons handing out leaflets, marching, whatever, picketing, whatever, would have to seek permission from the Director of Emergency Services 5 days in advance. And if that were granted, if the permission to do this were granted, it would be restricted to between noon and 6 p.m. on Monday to Friday. So now, fortunately, there was such a outrage over this that the university has now withdrawn that procedure and saying we're going back to the drawing boards to look at what to do. But
Jim,
what you're talking about is precisely what happened.
If I could chime in here, and it ties in with the earlier point you were making about collegial governance, I wonder if Canadian universities are governed as collegially as you might think. Because it seems to me that the Western example illustrates that there was this new policy developed and it maybe wasn't wide enough consultation. And indeed, as I understand it, when it was made public, there was like an after the fact consultation, which sort of dialed it back a little bit. So I think, and this also came up in the University of Toronto case, and at several points in the decision, the decision comments about the procedures for making changes through university governance. And so maybe these protests are raising questions about whether university governance as it currently is going to be sufficient for, and responsive enough, and even collegial enough.
Yes, there's been a lot of writing and research about collegial governance and whether it really works. There's a significant body of views that it exists on paper, but not in action. That you have these formal structures, but in fact, the academic body is largely marginalized. Others take a different view, but there's certainly no conclusive evidence that it works as alleged to work. Louis-Philippe?
And we may say that when we look at the reactions of university administrations all around the country, except maybe some places like UQAM, it was mainly a business approach. It was mainly kind of a vertical approach. It was not a collegial one. So we have to recognize, and the CAUT is recognizing it and is fighting against it. The fact that the collegiality universities are transforming and are drifting away from the collegial governance more and more, and that's a problem that we have to address. But the fact that when you're talking about the right of students to protest on campus, for me, it's an excellent example to be able to put forward in the public sphere the difference that still characterize universities and other public institutions at first. And for the debate between Jamie and Finn, I would say that maybe I'm in the middle. That I totally agree. I don't want to. I would do it anyway. So you have to fight for your right, not to party, but for your rights for sure. And we're talking about informal way of fighting for rights, but I will agree with Jamie for the fact that we have to, I think it would be beneficial for students to involve into a way of recognizing not fake policies that gives, it's beautiful on paper, but at the end of it, it's the administration that are purely decisional on what kind of protest that may be allowed on campus or not. And then the fact that we're not talking, not the fact, but a problem that we're not talking about, and it is invisibilizing all the tentative protests that are discouraged by the institutions refusing to answer those kind of, and refusing to give access to the protest because it was not 5 days in advance, quote unquote. And so the fact that vertical administration are putting more and more hoops to jump through to students that want to demonstrate on campus, it's a major problem. And for those kind of protests, I would be with Finn on that. You don't have to ask for permission. You are a student, you're part of a community, and I hope that in my course, I will teach that to my student. Just protest. And push the administration to a reaction. But if you are entering into this kind of structure, you won't have a right to disruptive protest. You will have a right for a festival.
Before we turn to the audience, I would like to finally just go a little bit into what we've talked about a bit, and that is with regard to the applicability of the charter, Canadian charter to universities. There was a Supreme Court decision, as all of you know, in 1990, the McKinney decision, where some faculty members of the University of Prince Edward Island claimed that their charter rights were abridged by the university's mandatory retirement policy. And Mr. Justice Laforêt, who's a former law school dean, said, no, the university is not government. The university has to have a somewhat reasonable autonomy from government. and therefore it can't be brought under the provision of the charter, at least with regard to these things. He didn't say it as strongly as I just said it, that it was acting as its autonomous self in doing that, therefore the charter does not apply. There's the larger question in law that you could address if we had time about, well, what kinds of non-governmental but public bodies or quasi-public bodies fall under the charter and for what purposes? And the Supreme Court, in a case called Eldridge, again, as you know, specified the criteria. And they apply to things like universities or schools or colleges or hospitals insofar as they're acting on an absolute directive of government in regard to a specific thing, and in that sense are government for the purposes of the charter. And so the understanding of the charter's applicability in about a decade ago started changing in Alberta, where for reasons of the nature of the Post-Secondary Learning Act, the Alberta Universities Act, in some specific decisions, the Alberta Court of Appeal ruled that the university had violated their obligations under the charter in the way they had disciplined students' free expression rights. Now, arguably, and this came up in Ontario because in 2018, Premier Ford issued a directive to all universities to have a very specific set of rules for freedom of expression and develop policies, gave them 4 months to develop it, indicated there would be penalties if they didn't, and appointed a quasi-governmental body to monitor with their compliance and to hold them accountable annually. So, I mean, one of the interesting questions is, insofar as universities crack down on these expressive freedom rights, especially in a way that allowed virtually no expression to take place as at York, whether those actually would be deemed unconstitutional were they ever be able to be brought to court. I think that's one of the open questions right now. I don't know if any of you have any comments on that charter aspect, which I just wanted to close off before we turn to the audience.
I'd just say a couple of things, which is, I mean, I think the argument is pretty strong in Ontario for application of the charter because of the 2018 directive, which engages in direct oversight of college and university speech policies. That's unavoidable. But then added to that is Bill 166, which has just recently been enacted, which deepens the government's oversight of universities in Ontario, together with all the statements and the statements by various government officials during the post-October 7th, sort of explosion of expressive activity in the encampments, calling on universities to crack down on their students and so on. It just seems to me really anomalous that the charter does not apply to this kind of protest activity. And I think it's very interesting to hear about the Quebec charter, and it's anomalous that the charter applies in Quebec, but still a big question mark whether it does in the rest of Canada. And when you think of what we've said tonight already about the nature of university institutions and the public discourse that is their reason for being, it just doesn't seem right to me that the university can be left with pretty much absolute discretion to determine how the degree to which they're going to tolerate rights of protest. And I got no problem with limits on rights of protest, but what I find really very troubling is the degree of overbreadth and the willingness of institutions to go immediately to complete prohibitions and blanket bans and really unnecessary kinds of restrictions on expressive activity. So I don't like the idea that the charter would apply to universities. I like to think that they're independent and autonomous and that they can do this for themselves, but I'm really not convinced at this point in time.
That's a really good point. It touches on a fundamental irony that this perpetual question outside of Quebec about the applicability of the charter to universities is, I mean, in the McKinney case, that one of the reasons that they give for saying they're not government is because part of academic freedom means that the university must not be subject to the whims of government in order to fully fulfill its role in searching for truth fearlessly and disseminating unpopular ideas and so forth. And so the Alberta case is a kind of a topsy-turvy world where, because the state has intervened so heavily in the administration of university affairs, therefore the members of the university of the community get the benefits of the charter protection, which I think is just a fundamental irony.
I mean, for any of you in Ontario, I'd encourage you to look at the bill that Jamie mentioned, Bill 166, which very explicitly gives the Ontario government the right to issue blanket directives with regard to policies on mental health care and on racism and hate. So that, I mean, basically the bill says the minister can determine what the university's policy will be. So we're really moving far away from the logic that was expressed historically about universities being autonomous and collegially governed to one where they're quite directly under the control of government.
And interesting, which seems to be at odds with the maybe because of the legislative enactment, but the court decision in Canadian Federation of Students, not the Supreme Court decision, but the one in Ontario where the Ford government had this defund student associations thing where Ford had said student associations were up to all kinds of Marxist nonsense, and therefore the minister needed to step in and say what fees could be collected by student unions. And the court said, well, there's no authority for the minister to just issue directives to universities. That's not how it works. That's not the relationship between the minister and universities. So maybe that explains why they then had to go with the 168. They actually had to enact legislation to give the minister that authority.
Exactly. Well, let's turn to the audience, if that's okay. Ange, do you have the first question for us?
Yeah, the first question, Stacy says, at my university, there's been reference to the duration of the encampment as having been particularly problematic. When the university president articulated this in our Senate meeting last week, I asked if there was any restrictions of the right to peaceful assembly associated with duration. I'd be curious to hear what the panelists think about whether there are any grounds for limiting freedom of assembly related to duration.
Very good question. Who would like to start off? I expect I might have something to say on this.
As I recall from the University of Toronto decision, the University of Toronto said that they were going to allow protest, I think 7 in the morning to 11 at night or something like that, but just not overnight. So it wasn't going to be a permanent protest. But the implication is, if you read the decision, that they can keep coming back every morning at 7 o'clock. Mm. And so there's this kind of, it's not permanent, but it can happen every day. It would be my take on that decision. And I'm curious for the other panelists' take on that point.
I think for my part,
there's a difference.
Sorry.
Oh, you go ahead.
Okay,
please.
I'll be short. I think for my part that the question of the duration, I totally agree with Jamie. It's central about the controversy surrounding the question of the encampments. And it's going back to the Occupy Wall Street movement. So the fact that the limits that were imposed by courts, I may be misled or I may be wrong, and you'll correct me, but it was about questions of security. Because if not, I haven't found one decision saying, okay, it's enough. You've been here long enough, and then you have to dismantle your encampments. The only decisions that I read about court's decision ordering a dismantlement of the Occupy Wall Street encampments were founded about security threats for people into the Indian encampments and people around, fire hazards. That we were about, it's what about it was about winter, and there were kind of heating systems that were dangerous, proven dangerous. And then this was the reason, I think, in BC that they decided to say, okay, we cannot allow it anymore because it's dangerous for the people that are protesting. If you're talking about, it's all about context, and it's all about the, I would say, the geographical of the campus. So if you're talking about McGill, the fact that they were using a quad in the center of the campus before the administration decided to lock the campus and to restrict the access only to members of the community, it will, from my perspective, from the moment it's peaceful, from the moment there's no threat to the security of anyone, duration is a central question, but you have to prove that there's something more than the duration alone. Because if you're going to you're able to protest, but only from 7 to 9, you are directly attacking the disruptive nature of the protest, from my perspective.
Jamie?
I don't have much to add because we probably have other questions. I think, though, that the root of it really was the occupation and the indefinite nature of the occupation of university space. So you could have a recurring demonstration, as Sarah suggests, you come back every day, but you're not occupying the space. Your occupation of the space is temporal and it's recurring. It's not indefinite and permanent in the absence of some agreement that it would end at a particular point in time. And I think those were those were the pressure points in these situations. Just the fact that, and some of the encampments self-described as permanent in nature.
Can I just point out a fundamental irony there? And that is, at night is the time when the encampment is actually not disrupting anything.
Right.
So the administrations get really, like, you could come here every morning and be here all day and that would be fine. But as long as you leave at the period where you're not being disrupted, which
Right.
seems to be a bit of a contradiction.
Staying overnight is what makes it an occupation, I guess.
Well, but I mean, the question I would ask you, though, in this regard, is it's not what it seems to me it's not whether it's an occupation or not, but whether the occupation is having some harmful effect on the university and the people in the university. So the location of it and what it's blocking, if it's blocking access to buildings, if it's taking up space that's essential to the operation of the university, becomes relevant. But if it's taking up space that's not essential to the operation of the university, and when there's alternative space for others who want to do equivalent things, is there a reason to shut it down? I mean, I think those are some of the questions that we have to.
They're not asking that question.
I'm sorry?
They aren't asking those questions because they
Exactly.
ban them.
I mean, as I recall from the University of Toronto decision, I think it's near the end, there is this comment that the encampment is preventing other people from accessing the property for free expression. And we saw that a little bit in Occupy Toronto, and the sort of the argument that, well, they can just go elsewhere. That's in the one sense true, but in the one sense it's also irrelevant because you can always potentially go somewhere else. And so I think that's one of the reasons why they didn't want it to be, what the decision decided against permanent, and we saw that in Occupy Toronto again. And I think some of these decisions even use the language of appropriation. And so there are all of these other security and, you know, other concerns that are raised, but when they're refuted, it turns to the sort of the argument that there's been an appropriation.
But again, I guess I'd press the case that, but doesn't it depend a little bit on the facts of the situation? The particular location, the University of Toronto, where the protest, where the encampment took place, was a big round area in front of University College that had been closed for the last 4 years because they were building a parking lot under it. And the claims that were made and what was being denied was students who wanted to eat lunch on that front campus couldn't do it. There was no suggestion of any university activity, and there's lots of green space adjacent to it in other places. So the question is, all those particular characteristics of a particular campus shouldn't they come into the determination rather than just arbitrarily the length of time it's going to be there is determinative, irregardless of all the rest is just the issue that I think we have to grapple with. The university is going to have to grapple with. And do you have a second question?
Yeah, the next question, somebody asked, have there been any charter challenges or other legal challenges in Canada against a university's decision to remove an encampment? And what are the prospects of success for such a challenge?
Well, as far as I know, there have been no charter challenges as yet, although I understand there may be some in the making. I don't know, do any of the rest of you have any information on that?
I haven't seen anything.
I only have anecdotal secondhand evidence of either of potentially lawsuits being filed, but it's interesting because those lawsuits could have different foundations, and one of them, which might be interesting, is the possibility of a suit for damages directly under the charter, which, since the Ward decision is now available, even though it would be coextensive with potentially with other heads of damages. So it's conceivable that well, certainly for those elements, for actual, for instance, if your tent was ripped up and all of your belongings were thrown in the garbage, I think there's a possibility for a claim there, but there may even be a charter claim. Yeah.
I think that, as a matter of fact, in the Quebec Université Laval case, there were fines that were given to some protesters, and those fines, I think, are challenged under charter's questions.
Under
So
the
it's not
Quebec charter.
it's not the litigation of a dismantlement, because there was no encampment, but they're kind of the litigation of the fines that were given to some protesters.
Well, in relation to English Canada, the two provinces where there is a basis for making the claim that it falls under the charter are primarily Alberta and Ontario with regard to freedom of expression. I'm not sure there's the same basis in other provinces. I don't know if others have a view on that.
Well, there's always a risk. So that's strategic litigation when you deal with interest groups like community groups, unions, and so forth. They make these decisions of like, well, is it ought we to try and file a claim in order to make the law advance? But there's always the risk that if you don't have a strong case, you're going to set people back for years, and maybe the uncertainty can be useful.
Okay. Ange, the next question.
Yeah, the next question, and this has come from a couple people, a similar question. And this person says, in Halifax, several student body groups encamp together at Dalhousie. Do students who don't attend the school where the encampment is located have different rights, protections around protesting there? Is the nature of the relationship with students legally different than that with non-students in these situations?
Who would like to respond to that?
Well, if I can give the sort of the technical, very sort of private law-based answer with respect to the students and the non-students, the relationship would be different. So when students enter campus and when unaffiliated individuals enter campus, they are technically entering under a license. There have been a few cases also about accessing university property for free expression where they tried to argue a contractual relationship, and that didn't really go anywhere. It wasn't quite so successful. So the basic point is that unaffiliated individuals, most universities would say they don't really have any right to be there, and they could at any moment be asked to leave, whereas they might follow a bit more due process with their own students. But they probably could ask their own students to leave as well. So it's a very interesting question, because that's kind of, you know, there's an obvious difference, but at the same time, it's not as stark legally, I don't think.
Well, and interesting, the consequences can work the other way, right? Because of if we put the license question aside, because of the contractual relationship between a student and a university, the university can impose sanctions, like for instance, a suspension or expulsion from the university on its own students, whereas the only thing they can do to other people on campus, for instance, would be students at another university, would to have security ask them to leave.
Okay.
It's a great point. Thanks, Ben.
And it was
Go
an
on, Kevin.
argument that was consistently put forward by administration, saying that the encampments were full of people not coming from the university. It was not a student protest. It was a bigger, wholer protest. And then it was giving speed to the property right argument, because they were not dealing with students. They were dealing with simple protesters that chose the campus to protest.
Okay, Ange, we'll try to get through a few more questions before we end. Go ahead, please.
A second question, another person asked regarding the charter challenge. In Calgary, there were students who were physically assaulted and injured with documentation. Does this change anyone's answers around a charter challenge against the university around the right to protest and freedom of expression?
Who would like to respond to that?
I will.
We're all avoiding giving legal advice.
No.
We're clear. We're not. Nobody's giving legal advice here. This is a discussion of a group of academics.
Maybe just go back to the paradox that was identified by Jamie and Finn about the fact that if you want the Canadian Charter to apply to your university, then you are kind of abandoning the autonomy argument. I think from my perspective, and I know that Jim won't be, won't agree with me on this one, but the best way to reconcile the university autonomy and the application of the charter to universities to a certain extent would be to recognize the fact that freedom of speech in the Canadian Charter also recognize or protects the academic freedom as an institutional guarantee similar to freedom of the press. And so recognizing that, you're able to recognize the fact that for some abuse of powers, as the one we're speaking right now, don't physical abuse against students, the Canadian Charter may be applied to it through the Eldridge framework to some actions that were linked to the public interest mission of universities, and the fact that the same charter recognizes a principle that gives the full extent of the university autonomy in the relations between governments like Doug Ford and François Legault and university directions and orientations. This is at the core of academic freedom. So I guess that this paradox, there's a way to reconcile the two opposite sides of this paradox, and I think it is through the recognition of the academic freedom as an institutional guarantee protected by the Canadian Charter. I'm sorry, Jim.
But so far as we're not in that situation, I'd really
know.
back to the
Yeah, well, I think
it's
that
an
for the
important
question of
asked.
cops beating protesters
Yep.
at the behest of the university, I think there's going to be a lot of just facts on the ground question in terms of, because technically, if a cop beats you up and there was no legitimate use of reason for them to use force, then it will be the police department, which is absolutely subject to charter to the charter that would be responsible. Now, it's conceivable that if evidence could be shown or put together that it was reasonably foreseeable, given the request of the university, that physical violence would erupt or happen, or that you had communications to the effect of "get them out, I don't care what you have to do" and so forth, then it's conceivable that the university could be liable. But I would suspect that in the case of if it's like the police in terms of the force of the state rather than private security guards, that the actual the defendant in that case would probably be the police force.
So, I mean, just to be clear, we have two separate issues here in a sense. One is, did the police violate your charter rights? And secondly, even if the police got you off campus non-violently, did the university, by calling them in, violate your charter rights?
Exactly.
Okay, can we go to another question, Ange?
Yeah, the next question, somebody asked, to what degree do these arguments change when we talk about faculty and or staff protesting? Is there a different set of responsibilities to these employees?
Who would like to respond to that one?
I would let Finn answer from my part.
Yeah, me too.
This is the question that I've worked on. That is that so in some senses, staff have there's a higher threshold. Like as a general matter, they ought to have less freedom than students, because the students have contractually engaged with the university. I know this sounds absurd for anybody who's an academic or who's been in a university, but the courts have held that basically it's like a commercial contract of service, right? The student agrees to be bound by university regulations, and the university agrees to give an education for money. But when it comes to staff, because of the nature of the employment relationship, staff have a duty of loyalty to their employer, and so they're subject to discipline by the employer, up to and including termination of employment, for a variety of things that could be characterized, for instance, as insubordination if the employer says, please stop, and they continue to do it, or if they're violating a clear prior directive by their employer, so forth. Or in some of the jurisprudence, if they're affecting the brand image of the employer, or somehow, or the reputation of the employer. But the counter side of that is that, at least when it comes to academic staff, the duty of loyalty is either in tension with or trumped by academic freedom, which allows professors to criticize their employer in ways that your average employee wouldn't be allowed. So it's a pretty thorny issue.
But I think the point you're making there at the end is really important. That is, academic faculty have rights, contractual rights, due to their collective agreement language on academic freedom, which about 95% of faculty in Canada have, which academic staff, non-academic staff, do not have. So the duty of the non-academic staff do have a duty of loyalty, whereas arguably the academic staff have the academic freedom, which is a fairly unique set of rights in almost any workplace in the country.
That's exactly right.
And another question.
Yeah, this one is from Alexander, and Alexander says, it sounds like the judge's findings you related rejected the accusations of anti-Semitism. Can you expand on the threat of weaponized / bad faith charges of anti-Semitism and how they will affect the campus movement and jurisprudence going forward?
I'm glad we're getting simple questions at the end. Who would like to start out on that one?
I would say that from my perspective, and I may be wrong, but the criteria when we're talking about speech that is dangerous, and when we're not targeting an individual, we're not talking about defamation, the limit was set in Canadian law to hate speech. And so even if you are feeling really uncomfortable, the threshold is really high in Canadian law, because it was said, and it was written, as a matter of fact, in the Watcott case, the fact that even if you are targeting members of a protected group through the right to equality, and you are, by your speech, by your words, affecting the dignity of members of this group, this is not enough to be hate speech. You have to get even more violent in your speech, and to be able to I don't have the English word, d'équivaloir, to be equal.
You know français.
Okay, that's good.
To count as
des craintes de violence, as a matter of fact, for members of those groups. So because of this standard, I think that the question has been ruled out for the moment.
I think it's been answered by all of the decisions that I've seen.
Yeah.
But the problem isn't necessarily, well, I mean, I'm sure there's going to be more litigation, and never say never, but there's also, I mean, there are things that you're perfectly entitled to say, that it's legal to say. that have consequences. And sometimes those consequences mean being painted with a brush that doesn't fit. And so in that sense, and I'd take it out of the context of this particular epithet, but in general, people being accused of things that make them kind of outcasts, and in French we would say infréquentables, people that it's not polite to meet with these people because of accusations, for instance, that they're a this or they're a that, they're a discriminator, they're a racist, etc. Those can have significant consequences, even if the speech was entirely legal and there's no direct method to have to silence them by law.
I mean, the question that was asked, I think, is a really important one, because a lot of the claims made by those upset by the encampments were that they no longer felt safe on campus, or that they felt harmed. But those are very vague terms, and presumably at one end of the continuum, there is a duty to provide safety, but I'm not sure it's the subjective sense of being safe that has to be protected. So I don't know if any of you might comment on it, because that's really, one sees that all the time in the debates about these about protests.
There's a huge amount of pressure right now to widen the scope of what is harmful, what is hateful, what is subject to regulation. And there are, we're way beyond, in terms of the pressures, we're way beyond our previous conception of what the boundary is between legal and illegal expressive activity. And I'm not clear in my own mind that we're capable of that kind of an expansion of concept to incorporate, I'm not going to say any and every, but all manner of expressive activity that is perceived and experienced as being harmful or unsafe. I mean, it's the reality of what we're dealing with now, and it's quite unpleasant. But the question is, what is the capacity of law and regulation to manage that issue, and is that the right solution?
Okay, let's quickly go to see if we can get in one or two more. Ange?
Yeah, the next question, somebody is asking, what would be the best ways to apply pressure on universities besides encampments, especially now that winter is coming up and most encampments have been taken down?
Well, now this is a question you're asking a group of law professors as to how you bring about social change. So with that caveat, go ahead and answer.
Put pressure for what objectives? Because there's a lot of ways to put pressure on university administration. So for the objectives that were pursued by most of the encampments, is that it?
Well, no, because you don't know what was behind the questioner.
Yeah, that's
so
really.
I mean, is it fair to say that it's not our role really to talk about how you more effectively protest?
Yeah.
But
Well,
there's lots of advice you can find out there about ways of doing it, and lots of people who've had lots of experience trying different things. So there's no sure.
Well, I'll venture a very broad ecumenical response to that without giving specific advice about specific causes. But I'll go back to something that I said earlier in the discussion with Jamie and Louis-Philippe. And that's that rights are won by fighting for them. And the one that I cite the most often is that striking was illegal in Canada in 1872. You could be thrown in jail simply for refusing to work in concert with your colleagues in order to bring your employer to have better wages. And in 2015, the Supreme Court of Canada said the right to strike is a fundamental right that's protected under Section 2D of the Canadian Charter. And the activity didn't change. What changed is the social consciousness around the activity, because people were able to make the case by defying the law that what they were doing is just. And I mean, there's a whole literature around civil disobedience, and I don't want to on this platform be seen as encouraging people to go out break laws willy-nilly, but there is certainly a space for changing the law through reflective, thought-out civil disobedience.
I'm afraid we're going to have to end there. We're sort of at the end of time. I'm sure we could go on and there are more questions, but I really do want to thank all four of you for a very engaging, enlightening discussion. I'm very grateful to all of you for willing to do that, and want to thank the audience as well for joining us this evening. And want to tell you, in addition, about our next event, which is going to be a week from tonight. It's entitled The Life and Death of Freedom of Expression, which is the title of a new book that Richard Moon, who's Distinguished Professor of Law at the University of Windsor, has written. He's one of Canada's leading constitutional experts on expressive freedom. And he looks at and explores how social media has added to the way speech can be harmful, while also undermining traditional legal protections. And while calls for greater censorship are growing, Moon suggests that the biggest threat may be disinformation, and addresses what can be done. So it's not going to be a book launch in the sense where you celebrate the book. It's going to be an interrogation of his ideas. And he's going to be in conversation with David Schneiderman, professor of law at the University of Toronto, exploring some of the issues. So in some ways, there'll be a continuation of a bit of what we've been discussing tonight. So that'll be a week today at 7 p.m. All the information is on the Center for Free Expression website, which is cfe.torontomu.ca. Just click on events, and you'll see the link for that discussion. As well, today's panel will be, a video of that will be posted on our website tomorrow. So if you enjoyed it or found it valuable, or have colleagues or friends that you think might enjoy it, draw their attention to, just come to our website and they can watch the video of it. As well, we're going to post a list of resources on these issues that we talked about tonight. So any of you who would like to read more about this, go into the law more about less legally difficult discussions, but more popular ones, the whole range will be there under resources that you can pursue. So I hope you'll check that out, cfe.torontomu.ca. Again, thank you to the panel, thank you to the audience, and good night.
Thanks, Jim. Thanks to my co-panelists.
Thanks so much, everybody.
And the audience.
Thanks, everyone. Yeah. Have a good night.
Thank you, everyone.
Night.